Our next topic, I think you've heard the word disparate treatment. A few of yes.
After last year, I was like,
Justin's fixing things. Justin's the one to blame for making you have to wait one more session to the cookies. But we're very happy on our next speaker. Among the topics they're going to touch on are disparate treatment, which has been mentioned a little bit previously, but there's some other hot topics. And our two speakers, first is Erica Probst, who's in the private practice of law, very experienced as a litigator, in many cases representing employees. And Wendy's kind of on the other side of the table, is the assistant chief of the employment law section for the Ohio Attorney General. And I found out this week, I guess you're supposed to have 15 staff, but you're down to what, 7 or 8?
We have 9.
To 9, so they're having to work harder and smarter, but challenges in terms of recruiting lawyers and everything else. So I'm now happy to turn it over to Erica and Wendy, and I'm sure there'll be a few questions. And we're on a hot streak with the audience, and I'm sure you'll continue it well. Thank you.
I am not funny. So we'll do our best. My name's Erica Probst. I'm an attorney in Columbus, Ohio, and I represent the majority of clients I represent are plaintiffs. And I know the SPBR because I represent them there when they've either been demoted or lost their job completely, etc.
I'm Wendy Clary. I am the assistant chief at the employment law section at the AG's office. I've been there for 10 years. My 20 years in practice has been all in employment law, and I've only represented employers. Sorry.
Super fun. Okay. So we get assigned disparate treatment because, generally speaking, when you are in a position in a public employment and you are terminated, and you go in front of the SPBR or file a claim with the SPBR alleging that that termination was wrongful, one of the issues that is prevalent is a disparate treatment. And in fact, that's so close. Okay. There's an entire administrative code section that provides what evidence the SPBR can hear to determine whether or not they'll hear evidence of disparate treatment. And basically, they can hear evidence of disparate treatment to determine whether or not the employer here, state agency, is applying their discipline unequally to certain employees, or they can compare the discipline itself, meaning same rule violation, but someone got a 2-day and someone got a written warning, etc. I think the first hurdle that we really didn't put in our outline is that when you're in front of the SPBR, if you intend to use evidence of disparate treatment, you have to give them notice of that, okay? And you have to give them a list of individuals that you think may be comparators, if you will, who then they can research those issues. You give it to opposing counsel, and they look into it. If you don't, you can't use it, generally. But I have a way around that. So we'll get to that last. I thought of this yesterday. I was like, I have something interesting to talk about. So anyway.
I'm interested in how you're going to get around it, so I know to look for it.
Okay, ready? All right. So disparate treatment. What is disparate treatment? I think everybody in the room knows what disparate treatment is. It is when two similarly situated employees are treated differently for engaging in the same conduct without differentiating or mitigating circumstances that would distinguish their conduct or the employer's treatment of them. So it's a really long definition, but the focus points of the definition start with the first 2 words, similarly situated. That particular, those adjectives, adverbs, no?
Sure.
Yeah, those are, they've been litigated quite a bit. I mean, it's ongoing. But what is it? So similarly situated employees require initially, in this scenario, the identity of the appointing authority. So using the Department of Corrections as an example, the warden at an institution would be an example of somebody who was an authority at that institution who provided discipline to these individuals. So if that individual is not the same, was not the same person for the comparator employees, they're not similarly situated. And it's not just the objective word warden, meaning during a 10-year period of employment, you could have had 3 wardens at the same institution, each of those wardens offering discipline on a specific rule violation to 3 different employees, but because it was 3 different wardens, despite the same rule violation, despite the fact that they're all lieutenants, it was a different warden. So under some cases, that would not count, okay, as similarly situated employees. But there are some circumstances, well, I won't go there yet. So you have to have identity of the appointing authority. And then the next issue that you run across is the actual conduct, okay? So you have 2 individuals who are both disciplined by the warden, who both, I'm using these examples because they're the ones with which I'm most familiar. We can use other agencies if you prefer, but right now I'm going to use those, okay? So you have 2 individuals, both work for the DRC, both have the same warden, both are lieutenants, and but they are disciplined under the same statute, but the conduct is different, allegedly. So that's when you get really into the minutia of what happened to the first lieutenant that did not happen to the second lieutenant. Generally speaking, if you're in that deep, you're going to get a determination that they're similarly situated, because that kind of factual analysis is going to take you a little bit too far for a judge to really decide, look, they're not similarly situated. You're under the same rule. You've got similar scenarios, although not identical, even though the definition says same conduct. There is not going to be a scenario where every single action is identical. It doesn't say identical, even though I think of identical and same as synonyms at times, but it doesn't require identity of conduct. So, for example, in a case that I handled in front of the State Personnel Board of Review, there was a correction captain who had shared something on Facebook that was offensive. And the sharing of that offensive item, specifically, and we'll just get into the facts of it so it's easier to talk about, he had shared a rainbow flag meme and indicated that if you can fly your flag, I can fly mine, and then he also shared a Confederate flag meme. He had shared some other flag memes associated with the Confederate flag, and one of his employees, an employee of the ODRC, saw those flags that he had shared, and she screenshot them and sent them to a coworker. And that coworker reported those posts. He ended up being removed from his position because he was in a position of a supervisory position where his employees were expected to look up for him, and his behaviors needed to be model behavior that wouldn't offend people he worked with, regardless. And so he was removed from his position. That was one of the reasons. As evidence of disparate treatment in that case, other examples of sharing of information were used. However, they were not identical. There was a correction captain who had shared a meme about shooting the sitting president in the middle of the road. A violent, satirical, likely, meme, but similarly, he went undisciplined. There was a deputy warden who had obtained the services of the current employees of the ODR, the specific reformatory, well, it was Ohio Reformatory for Women, to do certain signs that were going to be used in an event that were associated with, I think the sign said black power. The point being that none of those individuals were disciplined, but this particular individual was. They are not similar behaviors. The associations with the groups are not similarly offensive in that they weren't all the same groups. In fact, every single one was different. So the behavior wasn't the focus of the underlying subject matter, wasn't the focus. It was the similarity of the speech, meaning the sharing of unwork-related speech with other people that may be offensive to one or more groups of people. And it was the rule violation. They all had fit under the similar rule violation. So they all qualified in that scenario as comparators. The interesting thing is they were all, one was a deputy warden and two were correctional captains. So they were all, they weren't all, but they were different positions, but they all had the same appointing authority, the same warden. So in that particular scenario, the individual that I represented was I think he received 60 days of unpaid discipline, and then he was returned to work. So that is a scenario where you don't have identity of conduct, okay? And I'm not sure you ever will, okay? Maybe when it comes to attendance, but that's a completely different issue. So, but you have identity of a rule violation, you have similarity in the process as opposed to the underlying subject matter. So that is kind of an example of where you have individuals who have disparate treatment, but you don't have identity of the underlying behavior, nor did you have identity of the actual job, which I thought was interesting. So you're like, no, I don't. So anyway, the other thing that is interesting is in the case where you miss the deadline to create a disparate treatment defense, if you read the rule, the Ohio Administrative Code rule very closely, it specifically says that for purposes, that you can use disparate treatment for the purpose of determining whether or not the work rules are being applied selectively. Okay? It doesn't say that you can't use examples of other conduct that is similar, but that when you read the rule, it doesn't constitute a violation. So from my perspective, is the statute or the rule ambiguous? And to have the individual who may be in a scenario where potentially, and I had this happen, the warden who has to testify about the behavior which led to my client's termination had done something which violated the statute. And without giving her a lot of detail to go through her testimony and say, well, isn't it true that the statute, go through the statute and get her to admit that behavior, although she doesn't know it's hers until I bring it up after she admits that it violates the statute as she reads it, that the individual who had read it prior and not given her a violation obviously did not agree and thought the statute was ambiguous. It helps you create a scenario where you can argue that the behavior isn't a violation of the statute, as opposed to selective application. Okay, so you may be mincing words, but it works, okay? If you've got a situation where your person missed the deadline, but for example, that statute wasn't used to discipline other people, then potentially that's not what the statute is for. And they're trying to carve out a scenario where it is applicable. So use the actual statute itself, its ambiguity, and it helps your client regardless of the fact that maybe they didn't miss the deadline or maybe they're not comparators as we've defined it. You can use it in other ways, and that's effective at this level because notice and the due process element of the statute is important. That's all I have to say on that.
Okay, all that being said, what I wanted to do is my understanding is a lot of people here are in HR or are attorneys and who are, trying to make discipline decisions, or HR is calling you and saying, if you're an attorney, I've got this problem, I need to discipline this attorney or this employee. What can I do? Those are the calls that I get a lot from my clients. I've got a problem employee. This is what happened. A lot of times clients already call me what they know what they want to do, and they want me to bless it, right?
Right.
And they want me to say, you can do that. But some of the things that I want to lay out are sort of how to put yourself as an employer, HR, whatever, in the best position if an employee who is disciplined appeals that discipline in some fashion. So how many of you have a discipline grid or some sort of a grid, at your place of employment? Okay. So as much as I like discipline grids, I think that sometimes they're complicated because there's a lot of gray area in your discipline grid. The grid should always make it clear whether it is I have a client who you really don't skip steps. You do this, you do this, you do this, you do this. And then I have clients where they say in the introduction to the discipline grid, this is a guide. It's not set in stone. This is just supposed to be a guide. And so, the first thing I say when someone calls, I have a problem, I say, okay, what are the rule violations? And I think it's important first to get those right. We all have some catch-all, like failure of good behavior or something like that you could really just put almost anything into that. So when you're trying to decide, what to do with an employee, first thing is make sure you got the rule violations right. What rules do they violate? And I always tell my clients, explain to me why their conduct violated that rule. Because if they appeal, somebody's going to have to be explaining that to an administrative law judge. Why did this conduct violate that rule? And if they can do that, then and sometimes they can't. And it's like, well, we just kind of always put it under that rule. Okay, well, I like to dig a little deeper. So I always suggest to my HR people, have a sounding board in your HR department, and even say, okay, if this person appeals this discipline, how are we going to justify this particular rule violation? Some are flat out obvious, right? Attendance. You missed days. You violated the attendance rule. You stole something. You were dishonest. But the more of those broad catch-all categories are the ones that, when someone calls me, and those are the only ones they're citing, I'm like, okay, be able to justify why that rule was violated. Then look at your grid. What, for each rule, what does that look like? What does the grid say? And we all know that, if you have more than one rule, one rule violation is going to be start at a written, the next rule violation is going to start at a 1-day suspension. So you've got all of that, different options of what to do. And I tell them to write it down, make a little graph for yourself. This rule violation kind of starts with a written, and also, what is the main rule violation? What is really at the heart of why you want to discipline this person? What was the conduct? And sometimes there's minor violations, and there's this is the big one. This is the big rule violation. But it also kind of falls under these other ones, and we're going to cite them all. So I'm talking with my hands a lot. My apologies. So identify the rule violations, look at the grid. Then look at the employee's prior discipline. Do they have any prior discipline? Because if you're going to send somebody to termination with no prior discipline, it better be bad. Especially, if they're a long-term employee, because that's going to be the type of things that are going to be looked at when the employee appeals their discipline. If you have no prior discipline and you want to jump to a 5-day suspension or a termination, this better have been some pretty serious conduct, or there's a chance that it's just going to be overturned. Consider the mitigating factors. I just mentioned one, length of service. Did the employees seem to, most of these employees are, that go to PBR, they're all classified. So, right, for the most part. There are some exceptions for unclassified employees. But most of them have the due process, right? You bring them in, you haul them in for a pre-disciplinary meeting, and you talk to them, and you present your facts, and they get to justify what happened. Is it a situation where they, know they did something wrong and you think there could be rehabilitation there for that employee? I think that's something that sometimes the administrative law judges consider. Is it an employee who has shown remorse? Is it an employee who we can rehabilitate with a lesser discipline? Or was this employee just violated a rule that was so bad that we can't trust that employee anymore? And some of that comes into play too is, what type of employer are you? Are you a prison? You know what I mean? Where safety and security is a big issue. Are you, a county agency where, yeah, they violated the rule, and it was improper, but it's not, the consequence of the rule violation is lesser. So those are all things that I like to tell people to consider, and those are the things I talk about with each of my individual clients, because I know the client, I know their operations, and sometimes I don't. We represent all state agencies and state, institutions and colleges, and some of them are not. We have some frequent flyers because they're large, and they come around all the time. And then we have others where I've been there 10 years and I've had one call from them, because they just are small. So, figure out, are there mitigating factors? Length of service was one. Do they admit wrongdoing? Can they be rehabilitated? We already talked about the prior discipline. And also think about what are other options for discipline. Sometimes somebody needs to be terminated because of their position. Maybe they're a manager. Would a demotion out of a manager position that's still appealable, but would it be a better fit given what happened? Is it more defensible to just demote them versus fire them? Because if they appeal, you're going to have to justify all of this.
I have a question.
Yes.
I really always wondered this. Do you guys talk about the fact about having someone else having done this and only having given them this discipline or not disciplining them at all?
Yes, so that was next.
Oh, I'm sorry.
No, you're fine.
Okay.
No, you're fine. But yes, we have that conversation because the next thing I say is, because we walk through those and they justify, and we talk about mitigating factors, and they say there are no good mitigating factors, we want to fire them. And I say, who else has done this? And I caution people to take the time to go back and check. Because sometimes people will say, well, I don't know of anybody else that this has happened to. Well, how long have you been at this employer? 2 years. Okay, well, what happened 5 years ago? And it's hard, and I understand from an employer's perspective, it is hard to track all of that. You know what I mean? Do you have an online system? Or I still have clients that are all paper files, and they've got to pull out these files, and you're starting to go through personnel files to figure out what happened. But I do. That's my big thing, and this is not just for classified and discipline. This is for Title VII. This is for all of the calls I get from my client. We have to be consistent. My office just lost a case that cost our client a ton of money because of comparables. The plaintiff was treated a little bit harsher than other. It was sex and sexual orientation, and she was treated a little bit harsher than some men. Yes?
So I have a question. If you have, for example, a collective bargaining agreement or something in your personnel policy manual that says that records of discipline will only be kept for a short period of time and then they will be removed from a file, are you suggesting that there needs to be a super secret file somewhere where we keep this record? Because this is new to me.
No, we are the same way. And this is where there's a little bit of potential issues. So there's a retention, right? We have a retention at my office. After so many years, all the files are just gone. But what starts happening sometimes is somebody will say, I worked with so-and-so. They did this, and they only got, a one-day suspension, and you gave me, a last chance agreement and, and a 10-day suspension. It does make it hard because then that testimony can come in through somebody, HR, that employee, but there's no documents to support it. I'm not suggesting that you have a super secret file somewhere, but I do have some employers who start to keep like a spreadsheet, and it doesn't keep the documents, but it keeps sort of the bare bones of what happened. This person got a 3-day, this person got a 5-day. Sure.
So, like where many of the agencies that I work with, they will have a grid. However, the grid may say if you do a certain thing that your discipline can be 1 to 3 days.
Okay.
And so 5 people did it, 4 of them got 1 day, but the other person got a 3-day. They're all within the thing, so that person who got the 3-day claims disparate treatment.
So that's going to happen because there are some rules, like I said, that are very vague, right? Or they capture a lot. If they did the exact same thing, like to the T, the exact same thing. For example, attendance violation. I mean, Erica said she doesn't know situations where things are exactly the same, but attendance is one, for example. If everyone violated the attendance policy and one person, and in the same way, the same number of days, and one person got a 1-day, and 4 people got a 1-day, and one person got a 3-day, I think that's a problem. But if you're looking at dishonesty, for example, if somebody was dishonest, what were they dishonest about? What were the consequences of the dishonesty? Then I think you can discipline a little bit different under the grid, following your grid, but be ready to explain it. Be ready to explain to an administrative law judge, this is why this person got 1 day. This is why this person got a 3-day. One person who was dishonest, they lied to a supervisor about maybe, their time. The other person lied about, whether they let somebody come through security of a prison without being checked. Do you see how one is like, they're both rule violations, but one is more severe? You know what I mean? So I always just say, you don't have to, I say this carefully. To the extent that you can, I try to tell my clients to be consistent with discipline. But sometimes the facts of the case and what happened justify harsher punishment. But just have that justification.
The reason why is because one person initiated the thing that happened, and the other 4 followed the lead. So the person who initiated got 3 days. The other 4 got 1.
Yeah, the leader of the pack, who drug everybody with them. So sometimes I just think you have to be able to explain it and be ready to, understand that the judge could disagree with you. He could say, I think they should have been treated the same. And that's like, this is not like, there's an art to it, but it's not a science. You know what I mean? Because everything can be just a little bit different. Sometimes things are completely the same, but a lot of times there's a difference. Maybe somebody violated 3 rules and somebody violated 2 rules. The conduct was kind of similar, but there's an additional rule violation. Okay. I think that really walked me right into my last point, is that if you're going to discipline differently, you have to be able to explain it. And I don't mean just it makes sense to me. It has to be a strong explanation, because you're going to have to explain it to an administrative law judge, or HR, or somebody is going to have to explain why somebody had a harsher discipline for a similar rule violation. Maybe it's the rule's not exactly the same. It's the same rule, but the conduct is different. Or, as Erica, the Department of Rehabilitation and Correction is a good example. For example, one prison wardens, our position is that the wardens have the freedom to run their prisons as they see fit. What do they want in their prisons? Running a prison is a job that I would never want. I don't want that job. One warden may discipline somebody one way, the next warden a different way, and on top of all of that, you've got a central office, and that's where the director of DRC is. And sometimes a satellite prison, an employee is so high up in that prison, the warden's not disciplining them. It's the director. And so when you are then looking at comparators, you're looking at the director, and who did the director discipline in other prisons. And that was a case that I had with the State Personnel Board of Review. And the issue was who's the decision maker, and so therefore, where is our pool of comparators? Is it at the prison? Is it all across the state for anybody who the director disciplined or fired? And that ended up being what the administrative law judge ruled, that it had to be for the entire state of Ohio, anybody that the director disciplined was our comparables, which was Not my favorite, but, but it was accurate. It's accurate. So does anybody, before Erica's going to switch so we are going to sort of switch to a second topic. We had 2 topics. Before we switch over, does anybody else have questions?
So I want to make sure I heard you correctly. Did you say that you should get rid of discipline? You know, if our policy is that we would remove discipline after a year, are you recommending that we get rid of that? We keep it in a secret file? and really, the reason that comes to mind is if you were ever under investigation, to be able to show the history of an employee, to prove maybe why you had to terminate, that this wasn't a new issue, that you've had prior years of this particular situation. So, I mean, that's the reason I feel that we should keep it in case we ever had to go back to those files and pull that up if we were ever under investigation. I was just wanting to get your thoughts on that.
Yes, so we do have clients who, I think the initial question was sort of records retention. You know, every 3 years, you don't keep documents any longer. In that situation, I guess what I'm saying is you don't have to keep the discipline if there's a way to sort of track it to, a lot of people have online files now, although at our AG's office, our online files go away after 5 years as well. So I can't even pull up cases from 5 years ago in our system. But I'm not saying that you have to keep it. I'm not saying you should get rid of it. It's sort of your call. Like, how do you want to track your prior discipline? Some people pull it and, like I said, make a spreadsheet. You know, this is sort of the rule violations that we've had. This is the discipline that we've had. And they sort of keep something separate that's not subject to, the record retention policy. But that's sort of, and some people don't have a lot of discipline. Like, maybe you work someplace where you don't have a lot of discipline. But some of my clients are so large, and there's a lot of discipline. So they do keep track of the discipline outside of the record retention. Did that answer your question? Okay. Yes?
So, are you saying that different people have different retention? Everybody has their own retention policy?
My understanding is yes. Like, every employer, to the extent you have a records retention policy.
Yes, we do.
We do, obviously, but everyone is different. I have clients who have 2 years. I have clients who have 5 years. We were 7 years at one point. Now we're back down to 5 years. And it changes, ours honestly changes based on how much data we have. When we were keeping 7 years, it was so expensive to store. The AG's office is huge. So it was just too much data to store for 7 years. So we brought it down to 5. And there was talk about now bringing it down to 3. So yes, everyone I think has different retention periods.
Okay, so my question is, we were told by our county prosecutor's office attorney that you can't bring discipline from more than 2 years ago and base another discipline on the same fact if it's older than 2 years, unless it's progressive and you can draw it in.
Is that like a collective bargaining issue, or is that a county rule? I'm not familiar with county rules at all, so there could be that could be a specific county rule.
Because every once in a while we'll have somebody who every 2.5 years they have a big violation, but we can't bring it in.
This is like retention, though.
Yeah, I mean, that doesn't sound like retention as much as it sounds like a progressive discipline. Like, how long is your prior discipline active? Does it fall off in 2 years? Does it fall off in 1 year? That's, along those lines. And that's one of the mitigating factors, right? If the prior discipline has fallen off, you shouldn't be considering it. Mm-hmm. Okay. Unfortunately, from the employer standpoint.
We can't do progressive discipline because it's been 2 years, but she's been here a long time.
Yeah, that makes it difficult when, they wait till that other discipline falls off, then they've got a little bit more freedom to engage in misconduct because it's not building, you're not progressing.
You sound like they do it intentionally.
I would never accuse somebody of that.
It's an accident.
Just
Yes.
coincidental timing.
It is so weird.
Okay. Do you
Okay.
do your other one?
Sure. So obviously, we're going to switch over. Is that Is that okay with
Yeah, we got
everyone?
10 minutes.
All right, we have 10 minutes. Let's breeze through 9. Multi-generational issues in the workplace. I'm certain that everybody is experiencing this unless you have a workplace that has just one age group in it, like kindergarten maybe, and everyone's 5. So no, right? So there are multi-generational issues in the workplace, and they exist, and I feel like the gap is growing, maybe because time is changing, or there are certain things that are changing so quickly, from technology to how we do our jobs, that I think that there is a chance, because of these multi-generational issues, for a conflict between generations due to just attitudes based on the way you're raised, based on the way you're educated, based on a whole host of different factors. There's not a lot of my partners, I have one left, he's in his 70s, TikTok was not something that he was raised with. So, you know, his understanding and interaction level is based on something totally different than some of the younger generations that are coming into the workplace. And that difference is stark in certain cases, and it does cause conflict. And the first one that we've noticed, at least in and I work for a private employer, so some of the issues I have are different, but it's working from home, working at the office, and working overtime. So you bounce between different generations in the same office, and there are 3 different ideas about all of that. And unfortunately, I don't know if it's coincidental, or I don't even know how to say it, but generally it's all generationally tied. And I think that the issue for us in our place of employment is, how do we get past it? And we really we're struggling with it, frankly. The working from home issue tending to upset anyone who's baby boomer, 40 or over, and the working from home issue tending to be expected by anyone who's 40 or younger. And you know, some people want to discipline because they know they're not working from home, and then you've got I guess presumptions occurring, and unhappy office managers who want to discipline people who she knows aren't working from home, and they're out, I don't know, drinking tequila at a bar. Potentially, that may have happened. So, you know, so those I don't comment, no comment. So those issues, and it's not just that, it comes into workplace attire, the way you dress, the way the different generations dress, and I think the biggest issue is with digital accessibility and knowledge and methods of communication. I think that face-to-face, picking up the phone is something that I'm used to doing, and then the new generations wouldn't make a phone call or pick up a phone. You get a tweet maybe, or a text. It took me a while to know what the difference between those two was.
It's like that meme that says, this phone call should have been an email, right?
Yeah, that's right.
An email, like, why are we on the phone?
Right, because you have to be, because there's so and then you change policies to try to fit these generations, and you have complaints about that. And potentially some people feel in certain generations as if they're being discriminated against, the older generation, the younger generation, and I'm not sure how to deal with it, but it's there, and I think that it's everywhere, okay? I really do, and that it is leading to a lot of cases, at least in my arena, that involve age discrimination. And I think that as we move forward as a country of employers and employees, that it's going to continue. And I'm not, my only issue and reason for wanting to discuss it is, has anyone else seen that trend? Do they have that issue in their office, and have they been able to really find a way to strike a balance between any of these generational issues that has been effective? Wow.
Great.
Thanks. That's what I thought. I'm just kidding. What about you? Do you see that at the state at all?
We do. So, I had a training actually yesterday in our office. All of the chiefs and assistant chiefs had a training from the National Association of Attorney Generals. And a whole section of it was on this.
Oh.
And they talked about, how, there was an employer who cut Jean Day on Friday and lost 10 employees. And they talked about how, rule changes for a younger generation, they just are more apt to move on. A lot of the younger generations have had 3 or 5 jobs already, and they're still in their 20s, whereas somebody who's, older may have been in the same job. We have a senior attorney in our office who's been at the office for like 32 years, and he's only had this job. And so you see that where the younger generations are real quick to say, this didn't work for me, I'm out. See you later. I'll get another job. That's what we've seen a little bit more, but the focus yesterday was more on how to manage the different generations. And it's like a science. It's like, okay, so let me ask you some questions. So I got to do this with you, and this with you, and this with you. But we do see, people who are younger want to work from home a little bit more. They don't want the phone calls. And then we've got some people who are older who want to pick up the phone. I have some opposing counsels who he can call me, leave me a message, and I send him an email back, and my phone rings. And he's like, I see you're on your computer. I just wanted to talk through this. And I'm like, this really could be an email. But I like emails not, only because it helps me keep track of everything. There's so much going on. I can put my emails in files for cases, and it helps me keep track of everything. But we just try to get all of our employees together on a common ground. We'll go to a park on occasion and have a lunch and just sit around and find something to do to bring people together and try to bridge the gap, because, we've got some really young attorneys and some who've practiced for quite a while.
Right.
So you see the difference, with them. And we just try to find something that just we can all, kind of get on the same page with.
Free lunch works.
We
do a lot of that.
We don't do a lot of free lunch. We got to record all of our stuff.
All right. Well, that's it.
actually more
So
of a
our section is actually coming to an end. Do you have a question? Yes.
More of a comment. I think
Perfect.
sometimes you can build solidarity amongst the different generations by creating policies that everybody equally hates. Apparently, I'm very good at it. I highly recommend it, because then they will all complain together about management. So
Perfect.
that's also a way to deal
We're
with
going to work on that. I'm working on that. Yes, thank you. Put that in there. All right. I think that's it, though. Does anyone else have anything? No? We're right up to the end. Okay. Thank you.
Thank you very much.